On June 17, 2026, inside a Manhattan courtroom, a judge said something that should have set the tone for the rest of Luigi Mangione's trial. His lawyers were going to argue that when he allegedly gunned down United Healthcare CEO Brian Thompson in cold blood on a New York City street, he wasn't in control of himself, that he was suffering from what the law calls extreme emotional disturbance, that this wasn't a calculated assassination, it was a man breaking. It was a defense that could keep him out of prison for life, a defense that legal experts had been predicting for over a year as his best, maybe only, real shot. 24 hours later, it was gone, withdrawn. One line on paper with no real explanation. So what happened in that one day? And why would a defense team build a strategy for over a year, announce it in open court, and then kill it before the ink dried? That's what we're getting into. If you've been anywhere near the internet since December 2024, you know the name. Luigi Mangione, now 28, is the man accused of shooting and killing Brian Thompson, a husband, a father of two, and the CEO of United Healthcare, outside an investor conference in Midtown Manhattan. The killing turned into one of the most polarizing crime stories in recent American history. Not because there was much mystery about who pulled the trigger, there wasn't, but because of what it seemed to represent to people. Anger at the health insurance industry, frustration with denied claims and corporate greed, Mangione almost overnight became a symbol to some, a villain to others, and a defendant to the state of New York either way. He was arrested days later in Pennsylvania, allegedly carrying a weapon believed to be connected to the shooting, along with handwritten material that prosecutors say outlines a grievance against the healthcare industry. He's facing two separate prosecutions running on two separate tracks. A state case in New York, where he's charged with second-degree murder among other felony counts. That trial is set to begin September 8, 2026, and a federal case which includes stalking charges. That trial is scheduled for October 13th. Two trials, two juries, two very different sets of rules. And as we're about to see, that distinction is the whole story. Almost from the moment Mangione was arrested, legal analysts started speculating about how his defense team could possibly fight a case where the evidence, surveillance footage, the alleged weapon, the writings, was this overwhelming. CNN spoke with lawyers and forensic psychologists who pointed to one option that kept coming up, a psychiatric defense. Specifically, New York's Extreme Emotional Disturbance Statute, sometimes shortened to EED. Here's how it works, and it's important you understand this because it's not an insanity plea. It's not, he didn't do it. It's an affirmative defense, meaning the defendant admits to the act but argues that his mental state at the time should reduce the severity of the charge. If a jury buys it, second-degree murder can come down to manslaughter. The difference in potential prison time is enormous. In some outcomes, instead of decades behind bars, a defendant could be sent to a psychiatric facility instead. Legal experts called this Mangione's strongest card, maybe the only one he had left, given how strong the evidence against him appeared to be. But here's the problem they flagged at the same time. EED defenses depend on behavior. Prosecutors will tell a jury that someone in the grip of extreme emotional disturbance doesn't calmly leave the scene, doesn't evade capture for days, doesn't carry a prepared document explaining a grievance. Normally, someone acting from real emotional disturbance is too distraught afterward to function. They want to talk, they don't run, they don't hide their guilt. Mangione's alleged conduct after the shooting, the fact that he fled, the fact that he was apparently carrying written material, was already a problem for that argument before his lawyers said a single word about it in court. That's the defense his team appeared to be walking into anyway. So let's go to the hearing itself. Mangione appeared in Manhattan Criminal Court on June 17th, dressed in a navy suit, shackled at the hands for the entire proceeding. Judge Gregory Caro was presiding, and Caro had something to announce. Weeks earlier, there had been a hearing in this case that was sealed, meaning the public, and at the time even the full record, didn't have access to what was discussed. Caro explained why. He had sealed it specifically to give Mangione's team room to make a final decision about whether to actually go through with this defense strategy. Because of the nature of the defense, it would be very prejudicial if they ultimately decided not to use it. In other words, the judge was protecting Mangione from the fallout of even floating the idea in case it didn't end up sticking. Well, on June 17th, Caro announced that the defense team had made its decision. They were going forward. Mangione's lawyers would argue that he was suffering from extreme emotional disturbance at the time Brian Thompson was killed. The judge said he now planned to unseal those earlier sealed records. Prosecutors were given a deadline, Thursday, to receive detailed information from the defense about the psychiatric strategy. The same day, prosecutors made another move. They asked to transfer Mangione from the Metropolitan Detention Center in Brooklyn to Rikers Island, specifically to make it more logistically practical to transport him for psychiatric evaluations at Bellevue Hospital. One more thing happened at that hearing that's worth noting. A separate charge related to possession of a large-capacity ammunition magazine was dismissed. Not because of the psychiatric question, but because a judge had earlier ruled that the magazine was improperly searched by the officers who arrested Mangione back in Pennsylvania. Prosecutors agreed to drop it rather than fight that ruling. So by the end of June 17th, here's where things stood. Psychiatric defense, confirmed, on the record, in open court. Records about to be unsealed, evaluations scheduled. Assistant District Attorney Joel Seidemann, representing the DA's office, at one point accused the defense of stonewalling prosecutors by withholding information about the strategy up to that point. It looked for a moment like the trial finally had its shape. Then came Thursday. The same day Mangione's legal team faced a deadline to hand over his psychiatric records to the Manhattan DA's office, they did something almost nobody saw coming. They withdrew the defense entirely. The filing wasn't long, it wasn't dramatic on paper. One line, the defense respectfully withdraws CPL Section 250.10 notice at this time. That's it. That's the whole notice. No extended explanation, no press conference, no detailed walkback of the reasoning, just a single sentence undoing what had been confirmed in open court less than 24 hours earlier. But we do have some insight into why. According to a transcript released the same day, Mangione's legal team told the judge, back in early June, during that originally sealed hearing, that logistics tied to the federal case were making it difficult to move forward with the emotional disturbance strategy. Here's the conflict. The federal case against Mangione, the one with the stalking charges, set for trial in October, does not allow for an extreme emotional disturbance defense. That's not an option under federal law the way it is in New York State Court. So Mangione's attorney, Karen Friedman Agnifilo, pushed back hard on the judge's plan to unseal the psychiatric defense materials. Her argument, doing so would be prejudicial to his defense on the exact same facts in the federal case, where this entire defense theory isn't even legally available. Think about what that actually means strategically. If Mangione's team lays out in detail an argument that he was in a state of extreme emotional disturbance, admitting intent, admitting the act, but framing his mental state, that record doesn't just disappear when he walks into federal court a few weeks later. Prosecutors in the federal case could potentially use that same material against him in a courtroom where the defense that justified saying it in the first place legally doesn't exist. In other words, the psychiatric defense might have helped him in the state trial and actively hurt him in the federal one. And once the judge ordered those records to be unsealed and shared with prosecutors, that risk became real instead of hypothetical. So they pulled it. Same day the records were due. One line, reversal complete. Let's be clear about something. Withdrawing this notice doesn't mean Mangione's mental state is off the table forever, and it doesn't mean his defense strategy is settled. The filing specifically said the defense is withdrawn at this time. Language attorneys don't choose by accident. That leaves room for them to revisit it, depending on how the federal case develops. What it does tell us is that Mangione's defense team is playing a two-front war, and for now, they've decided that protecting his position in the federal case matters more than locking in a psychiatric strategy in the state case, even though legal experts considered that strategy his strongest option. It also tells us something about how thin the margins are in a case like this. Two prosecutions, two jurisdictions, two sets of rules, and a single piece of legal strategy can become a liability the moment it crosses from one courtroom into the other. Here's where things stand as of right now. State trial, September 8th, second-degree murder among other charges, no confirmed defense strategy following the withdrawal. Federal trial, October 13th, stalking charges, psychiatric defense not legally available there. Mangione has pleaded not guilty in both, and we're still nearly 3 months out from the first trial date, which means whatever decision his team ultimately lands on, we likely haven't seen the last reversal in this case. What happened over those 24 hours in June isn't just a procedural footnote, it's a window into how high-stakes a defense strategy decision really is when a defendant is fighting on two fronts at once. One sentence in a state courtroom can become evidence in a federal one. One legal theory can protect you in front of one jury and bury you in front of another. We'll be following this case as it moves towards September. If there's another development, another reversal, another ruling. We'll be back with it. If this kept you informed, hit subscribe so you don't miss the next update on this case.